Interviews you granted yesterday. Today is day 2 after that decision was made. 2 days after the decision. Are your reflections the same?
No, if you can repeat that question.
I was asking 2 days after the decision was made. Are your reflections when you go back to the case, are they the same or there are new things that are occurring to you about how it could have gone, how it could have been done better, and what you feel about the whole process?
I just believe that, so once again, good morning. I just believe that no Ghanaian, whether Jewish, Muslim, Christian, Ewe, NDC or NPP or PPP should be made to go through what the honorable person was made to go through. It should never happen. It should never happen to any Ghanaian. Look, Senna, this matter, I have been associated with it right from the beginning. In fact, somewhere in November 2017, my client, the Honorable Forson, drew my attention to the fact that Tamakloe has a letter for him, and that he is invited by EOC to come and assist with an investigation. And that we should come. So I recall when we met Speaker Okwe, he directed us to look. My good sir, led by my senior Dr. accompanied the Honorable Forson to Yoko. Hello.
Yes, I can hear you clearly.
So we accompanied the Honorable Forson to Yoko. When we got there, it was, we met the Deputy Executive Director of Yoko. So this matter has been referred to me by ADPs. And for that matter, they want our assistance to enable them to the investigation. So now, when we received the message, we went there, and the Honorable Forson said, listen, the letter you sent to me, you see assigned for my boss, the minister. Is that correct? He said yes. And you can see that I have copied my minister in the letter. Is that correct? He said yes. So now by the time we were done, the EOCO officials now asked us that we should take the police form, go home, write our statement, and bring it later. So now listen know. So we took the form, went home, wrote the statement. I had to go to Honorable Forson in Parliament, took the form and submitted it to you. So now, from November 2017, the police never called Honorable Forson again. They never did.
After you submitted the police form with the statement of your clients?
Yes.
No follow-ups, no calls. You never heard from them again?
No, look, nobody ever called us. I repeat, nobody ever called us. And this was 2017.
Okay.
Now guess something. Guess what happened? 19th November 2021. The 2022 budget was read. When the 2022 budget was read on November the 19th, it came with a e-levy conversation. You remember?
Yes, vividly.
So, as usual, the Honorable Forson said the minority were opposed to the introduction of the e-levy law. Guess what? 25th November 2021, we received a call from the Speaker of Parliament that Yoko have sent a letter that they are looking for the Honorable Forson. So again, they called me and I said, okay, we are ready. So Speaker offered his conference room. Hello?
I can hear you clearly.
Speaker offered his conference room for us.
Okay.
He offered his conference room for us.
Okay.
So we went there and met the investigators from Yoko. Then we indicated that since we volunteered a statement to them earlier, we will rely on that statement. You understand?
Mm-hmm.
The one we gave 2017, we will rely on it.
Okay.
Then it's okay. But we indicated that if they could get us a copy or something.
Mm-hmm.
So they said, okay, then let's come back another time. Immediately the EOCO officials moved about less than 5 minutes or 10 minutes. Then the investigator called me. He had my number.
Mm-hmm. So
he called me and said, look, he had just received instruction from the AG's department that at Forson, they need a charge statement. You know, for the criminal process, there's usually a caution statement, then a charge statement if they want to go to court. And that his instruction is that he must get the charge statement now. So I said, no, there is something amiss. Let's put that aside. So if you recall, 22nd December, the charges were filed.
Yeah.
January, we started a trial. We applied for bail, and he was granted bail. National, the Attorney General of the Dame called 5 witnesses. 5. So each of the witnesses, an official from National Ambulance Service, an official from Bank of Ghana, where the request letter went to. There's one Edudzi, there's one the investigator, and the then Minister of Health. He was the complainant, Kukwadima.
Okay.
So after each of the witnesses came, we did what is called a submission of notice. When we did the submission of notice, then the judge knew that we have a case to answer. Hello?
Yeah.
That we have a case to answer.
Okay.
We said, no problem. We appeal that decision for us to open our defense. It is that decision that was delivered on Tuesday.
Okay.
Now, I want to run you through You have a copy of the judgment.
I do.
I wanted you to open to page 25.
Let me quickly then find it. But there's
page 25.
Okay, so on 25th November 2021, I just want to take you back to something you said whilst I find that judgment. You're saying when you met the investigator, and the investigator insisted that he takes a charge statement.
When we first met them, we agreed on meeting another time.
Okay.
So they left.
Okay.
You see the speaker's office. Right in front of the speaker's office, there is this platform.
Okay.
It's like an arena. So they use that, like going further down, to take their car. So on the way, then they call me back.
Oh,
that
so
they have a firm instruction. Hello?
No. So you're saying that originally the meeting had ended, they left?
The meeting ended.
Okay.
And they had left.
Okay.
So on the way, then they call me back. That they have a firm instruction.
Firm instruction?
Firm instruction. And that they have just been called. So
okay.
After, it's like somebody was waiting to take the charge statement. You get it?
Okay.
Then, so the person had to brief someone at the age that based on one or two things. So less than 5-10 minutes, it's like they were walking to the car park. When the call came back to me again, that no, they need the charge statement here and there. So I knew that there was something amiss.
I see.
Hello, sir.
I see. Did they tell you where the instruction came from?
Obviously from the AG department. I know the person who they spoke to. I think he's at this point.
You know the person? Who was the person?
Definitely somebody at the AG department, but just to, we talk with investigators, and so you don't want to disclose certain information.
I see. But you're going to, you said you're going to refer me to a portion of the judgment.
I said, have you opened it now?
Yes, I have it.
Now go to page 25.
Page 25 of the judgment. Okay. And there, yes, I can see it.
Now go to paragraph 65.
Okay. I can see paragraph 65.
Have you seen it?
Yes, clearly.
Okay. Now, can you read it?
Okay.
Or I should do the reading?
No, don't worry. This is paragraph 65, page 25 of the ruling. Says, I know that Mr. Tamakloe in particular said in his evidence for whatever reason that the first appellant instructed the Bank of Ghana to establish an LC in favor of Big C in the letter of August 7, 2014. At trial, he was challenged on the use of the word instructed. And in my opinion, he chose to equivocate on it instead of accepting it. In my view, this was a necessary posturing because the first appellant did not use the word instruct, but rather requested in the letter he wrote.
So, Senator, so that's where the mystery started. So this man figure is the Bank of Ghana official who worked on the request. Now he offered a witness statement to the court and took an oath. In his witness statement, he said, Honorable Arthur Forson instructed the Bank of Ghana to set up the LC. Under cross-examination, we now showed him the letter dated 7th August 2014, for him to point out where Honorable Arthur Forson said or instructed the Bank of Ghana to establish the LC. He then said his use of the word instruct was wrong, and that what Honorable Arthur Forson used was request. He knew the legal consequence of both words. To instruct is to command.
Okay.
To instruct is to order.
Mm-hmm.
And that becomes like an obligation or a task to be performed.
Okay.
But to request gives you the opportunity to decline.
Okay.
So say that if I request something of you, you have the opportunity to decline.
Mm-hmm.
But immediately I instruct you, it becomes a different matter.
Okay.
So he puts in his witness statement that Arthur Forson instructed. Now when we show him the letter, now where is the word instruct? He started playing games. And so you will see that the Court of Appeal remarked that he started doing what? Equivocation.
Yeah.
Now, proceed to paragraph 66. Very instructive.
Paragraph 66.
66, the immediate paragraph after what you just read. It starts from Mr. Margaret.
Okay. So paragraph 66. Okay. Says Mr. Marquet told the court that the letter of August 7, 2014 was on the letterhead of the Ministry of Finance and was signed on behalf of the minister. See pages 158 to 159. Okay. Says Mr. Marquet also stated that the LC is not a payment but a guarantee. This transpired on June 7, 2022 when he was cross-examined by Dr. Bamba, counsel for the first appellant. Question. So you will agree with me for this explanation of the letters of credit that a letter of credit itself is not payment, will you not? Answer, yes, my lady, but the letters of credit guarantee payment. Question. A letter of credit guarantees payment subject to certain conditions being met. Is that correct? Answer, yes, my lady. Question. It therefore follows that the conditions and the letters of credit had not been met. Okay, it therefore follows that if the conditions under the letters of credit had not been met, then payment will not be made, correct? Answer, no, my lady. It is only when conditions are met that the payment will be made. Okay, that's it.
So this is the prosecution's own witness who under cross-examination now admitted that the letters of credit was not payment, but only a guarantee of payment. And that there are even conditions that must be met before payment can be made. Senator. Now, if you come to paragraph 67, something happened. Malos, the evidence also establishes that the witness told the court that the first appellant was not the applicant for the LC, but the Ministry of Health. Again, this is what transpired when Mr. Marquet was further cross-examined after counsel tendered a document, Exhibit 1 for A1, to the witness. Now listen. Take a look at SB 1 for A1. It has a column for applicant. Does it not? Answer, yes, my lady. The applicant herein refers to the entity applying for the letters of credit. Does it not? Answer, yes, my lady. On Exhibit 1 for A1, the applicant is stated as Ministry of Health. Is that not? Answer, yes, my lady. Senator.
What was the real point of this line of questioning that the Court of Appeal then focuses on?
Is to establish that Forson was not even the applicant for the LC.
That Forson and the Ministry of Finance were not the applicants?
No. They only requested. And remember that the contract is not between the Ministry of Health and Big M, the Ministry of Finance and Big C. It is between Ministry of Health and Big C. That because it's a letter of credit, it must come from the Finance Ministry. So the request is done on behalf of the Health Ministry. Now, if you go further on that line of cross-examination, the witness also told the court that the document of payment includes a whole lot of stuff. So even before payment can be made, they do shipment document, custom document, and all of those things. Those things are not with the Ministry of Finance. They are with the Ministry of Health. The agency that applied for the LC. Now listen, page 68, paragraph 68. When the cross-examination continued, the following evidence was further elicited. Question: who signed Exhibit 1 for A1? Answer: it was signed by the Controller and Accountant General and the Deputy Controller. Senator.
Okay. Yes. What is Exhibit 1?
Okay.
What is the Exhibit 1?
No, Exhibit 1 is the actual application for the LC.
Okay.
And it states in there, the LC. It states in there that the person who applied for the LC is the Ministry of Health.
Okay.
And at the bottom, the controller now signs together with the deputy, authorizing for the amount stated herein to be debited from the account.
Okay.
And Forson was nowhere.
Okay.
So if we look at the further question, so you agree with me that A1 was not the applicant in Exhibit 1 for A1? Answer: I did not get the question clear, so we repeat it. The question is that A1, Honorable Forson is not the applicant indicated on the Exhibit 1 for A1. Is that not so? Answer: no, my lady. Honorable Forson is not the applicant on Exhibit 1 for A1. Senator. Notwithstanding all of these things on record, the trial judge insisted. So now listen to what happened. Mr. Kuku Ajiman also testified about the letters of August 7th by first applicants to request the LC. I note, now listen carefully. I note that he initially said the LC was requested without the notice of the Ministry of Health. But when he was confronted later about it under cross-examination, he accepted that his initial position was wrong. Kuku Ajimane also said the LC is not payment, but a guarantee. Again, the following is what happened. Question: you have also served as the chairman of the Public Accounts Committee in Parliament. Is that correct? That is correct. So you have quite a working understanding of how LCs operate. Is that correct? Yes, I do. Are you aware? Are you not? That LCs are not payment in themselves, but are guarantees of promises of payment subject to certain conditions. Guess his answer. That is so. He is the complainant. He took the matter to Yoko.
Yes.
Now, listen to what happened. Bishop Ikwajima told the court that if LC has not been established, payment cannot be authorized. He also said that even though the letter requesting for the LC is the primary document, the Bank of Ghana will not be able to establish an LC with a letter only. Okay. So the Forson letter alone is not enough for you to set up an LC.
Okay.
Now listen to this. Interestingly, despite the very clear, unequivocal answer above that an LC was not payment but a guarantee, Kweku Agyeman later gave a different answer on August 30, 2022, when he said, per the terms of the contract, payment should be done by LC. Therefore, a request for LC to be established meant requesting for payment to be made. My loss, due to the inconsistencies in the record of the evidence of Mr. Agyeman, I consider his later evidence as unreliable, and I place no weight on it.
So the man who says it will not be enough to even establish an LC with a letter from the finance ministry later said that
suddenly changed.
Okay.
So after his testimony, the next time he was coached to now change his testimony. Thankfully, the Court of Appeal judge found him out. So now, all these things were on record, and the trial justice said we should open art. So listen to what the Court of Appeal remarked about this invitation for us to open our defense. Listen to what the court said. I am of the opinion that the evidence does not show that by offering the letter of August 7th, the first applicant caused loss to the state or misapplied the property. Now, this is what he said. There is no evidence that the loss was caused as a result of an omission by the first appellant in authorizing the letters, or that he intended to cause a loss to the state or took an unreasonable risk on it. Based on the record of appeal, I am of the respective opinion that there is a lack of logical connection between the evidence and the finding of the court that a prima facie case has been established.
See.
Hmm?
And that's what you've been arguing all along? That's what you've been arguing all along?
That is what?
Is that what you've been arguing all along? That connection was not made?
All along. Look, the people whose testimony and the crosses are made against you are prosecution witnesses. Remember that at this point, Honorable Forson had not called any witness whatsoever. These are prosecution witnesses. These are the people who came to court to build up the charges against Forson.
See. Now, you made these arguments before the trial judge.
Oh.
She gave a ruling. Then you went to the Court of Appeal. Is it what in her reasoning made you decide to go to the Court of Appeal?
Let me read something to you. Page 76. Paragraph 76. It's 78, sorry. Further, the evidence establishes that first appellant's approval was not sought by Bank of Ghana before payments were made, but rather the Ministry of Health. As the applicant, the Ministry of Health was the contracting party and had the responsibility to ensure that all conditions for the LC were met before payment. The Ministry of Health was to ensure that the pre-shipment inspection had taken place and all conditions of the LC were before payment. Not doing so, to my mind, was inexcusable and reckless because it is the Ministry of Health which approved for the payment apart from those orders the courts made. So, another prosecution witness called Edudzi. This is what happened. Against tribes, and in this case, Mr. Edudzi Mensah, in his testimony, affirmed that in all situations, the Ministry of Finance authorizes and approves public finance of ministries and effect government departments. And to that extent, it is my view that requesting the issuance of an LC on behalf of the Ministry of Health was not out of place by the first applicant as the Deputy Finance Minister. This was done after the Attorney General had received notice of intention to sue in breach of the contract by BC and advised the Ministry of Health of the consequence of non-compliance. So now, can you imagine?
See. So it was based on the facts that you decided to challenge the judge's ruling on the application of no case?
Hello?
I was asking whether it was based on these facts that you decided to challenge the judge's ruling on the application of no case, because there are times when...
Yes. We said, look, if this is what the prosecution witnesses are saying, then there's no point for us to even open our defense.
And having gone through the entire judgment of a court of appeal, the Attorney General completely disagrees. I'm sure you've seen that statement he issued. First of all, your response to that statement?
The Attorney General, in his statement, says that the judgment is inimical, is unfair to the nation, and inimical to the fight against impunity and abuse. These were his words, correct? And that the judgment is perverse.
Yes.
These were his words.
Exactly.
If there's anybody whose conduct has been unfair to this republic, it's Godfrey Edudzi.
His conduct has been unfair to the republic?
Yes. If there's anybody whose conduct has been inimical to the fight against impunity, it's Godfrey Edudzi. I have never seen an Attorney General abuse his office like Godfrey Edudzi. I've never seen that. This is an Attorney General who abuses his office to the extent that he goes ahead to, engage an accused person who is duly represented by a lawyer with the sole purpose of securing conviction at all costs. The current Attorney General had misconducted himself so grossly that he's not fit for purpose. He's not fit to continue to hold the office of Attorney General. Godfrey Edudzi has no shame. The thing called shame, God never gave him any sense of shame. Look, a very reckless and terrible person who would do anything and anything. There's a guy who goes to a Supreme Court judge. One day we'll talk about that. He goes to a Supreme Court judge and tells the Supreme Court judge that help me, connect me to your cousin, Japan. So I can get him to implicate. So, on the 25th of March this year, Do you know what happened?
25th of March this year, 2024.
Godfrey Dame went to Justice Kulendi's house. Justice Kulendi called Richie Jagba and gave the phone to Godfrey Dame to speak to Richie Jagba for 17 minutes.
Okay.
So now, let's see how the coming days will be. Now, Sena, you know why all this matter became an issue? Hello?
Yeah, I'm listening to you.
You know why this became an issue?
No. Tell me.
So you see, the Akufo-Addo administration took over in 2017 and even started talks with Big C.
Really?
However, oh yes.
In 2017, when they took over, they were having talks with Big C.
Because the contract as we speak has not been abrogated.
Okay.
However, the president's daughter wanted the same ambulance contract.
Oh, okay.
Yes. So, you would notice that the companies that supplied the 307 ambulances.
Okay.
The first company is called ELOC, E-L-O-K, Consult and Services. Guess who the directors of this company are? Stephen Okoro and Solomon Okereke.
Yes.
Guess what? The other name of Solomon Okereke is Solomon Okoro.
Okay.
Siblings.
Yeah.
Stephen Okoro has a daughter with the president's daughter. In fact, the president's granddaughter. The father is Stephen Okoro. You see where the thing is? And so they needed to sabotage and bastardize this one to justify what they wanted to import. We'll get time to discuss that matter one day.
I see. You're saying that this case is connected to the 307 ambulances.
Perfect.
And the connection is that as long as this contract exists on paper, they will not have cause to import ambulances in the manner in which they did.
Because it was the Ministry of Health that signed the contract. Is governance not continue?
Yeah.
Yes. But how are you going to contract a new contract altogether? When you are fully aware that there is an existing contract for supply of almost 200 ambulances.
Okay.
So now, that is why I said that we should be careful not to allow any Ghanaian to ever go through this.
Let me conclude then by asking you this, because I realize, and this morning the WhatsApp newspaper has been published a story in which they say there are disagreements within the Bar Council.
The bar council.
Yes. You made a post where you seem to have backed those who are suggesting that Godfrey Dame should not be allowed to address the conference. Why?
At this point, is it fit to continue to be the leader of the bar? Certainly not. This guy is immoral. immoral. So now we'll talk.
Oh, no, but to suggest that based on, because at this point in time, there has not been an official investigation. He's not even appeared before those who are supposed to address matters of code of ethics, among others. So what's the basis of based on hearing from one side? Yes.
When you sleep and you rain, you didn't hear. When you wake up, you will see that the floor is wet. Has Dr. Dami denied that the 9 April 7 a.m. call to Richie Japa, the recording is not his voice? Nobody can whitewash Dr. Dami. Not even the devil.
I see. And talking about March 2024 means that you have further evidence which you put out?
No, if you can proceed.
No, you're talking about the fact that there was an incident in March this year when he went to the house of a Supreme Court judge. The Supreme Court judge calls Richard Japa and gives the phone to Godfrey Dami to speak to him. That is not the recording that's currently in the public domain, is it?
Absolutely.
And you do have the March conversation.
Oh, your ear they switch you.
Why? I know I have a duty.
Relax. You know me, I won't say anything that hasn't or has never happened. When I told you about Stephen Okoro, were you back to me?
No.
Huh? The first time I told you about the president's family's connection to these ambulances, you thought I was joking. I'm an investigator.
Well, congratulations once again.
Lawyer, answer now because me can say some time ago no. Big C fui omadwen senka sikano. Omobe ma nanka case no ye judge ready. You see Godfrey Boadami su di case na chia business. He says kan sa hwere yan yonti no. We no metimi asiu age ana.
Ma exna and decide here.
Sa okay. Any congratulations. The any dey say wo pay man kani fufu on.
So I'm saying said you will a classic akra.
Yeah, meaning pa.
It's not the ya man kani fufu no. You kwa fuma. Ya ni ye dog rare. You fufu. The nyamu kuya. And then when you ma na ya fufu no. Why you? It's a very pretty man. Can you go one? I hear brown wings and not because I just a man can you now.
Aye.
It's a new bunch of cacra. Near the man can you need the account. Yanya amokuya. Anaja can't you? Na aja. Yaya dear bed. It's a man can you put the air the bar.
I see.
And yeah.
I see.
What now after that?
Oh, my tenocracy dobro DNA man canini kati kankati ina.
Now, when we say Oko a champion, from the dog community, so
pa edding papa.
Exactly.
I see.
And yes, every crowd, what can happen?
By the way, Crimea for the phone cooking now. You see, in the head,
I see. Now, before you go, there's a comment from Senna, from Domi Pillar 2, says I should ask you where the ambulances, where are the ambulances and the accessories?
Oh, the accessories are the ports. The ambulances are the military base.
Okay. Okay.
My information was that even during COVID, they quickly put some together and use it during the COVID event.
The ambulances.
The people we are dealing with are evil and diabolical.
You meant you're saying that they actually I don't know how to put it. They retrofitted.
They went on time when COVID struck.
Oh, really?
When they will talk.
Thank you. Thank you very much for speaking to us this morning.
Have a blessed day.
And I wish you all the best. Yeah. Lawyer Godwin Edudzi Tamakloe is one of the lawyers of